Good evening, everybody. Welcome to another edition of Reasonable Doubt, presented to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Damon Parrish. And tonight we welcome to our program past president of the HCCLA, Pat McCann, along with current board member, Casey Gautreaux. We've had a lot going on this week. It's been a big week in the Supreme Court. We've got a lot of other issues going on around the city and the state. So we're going to get right into it tonight. I'm going to bring in my co-host, Damon Parrish. Damon, how are you this evening?
All right, yourself? And it has been a big week.
I'm doing great. There's been a lot going on. We've had some interesting positions taken by our elected officials in Austin, and
the world has changed.
The world has changed. It's a brand new world, as they would say, and we're going to get into that a little bit later in the show because I think that's going to be a big, big chunk of our time. But I want to welcome to our program tonight Pat McCann, Casey Gautreaux. Thank you guys for joining us.
Thank you for having us.
I really appreciate you guys coming on. It's been let's put it this way, it's been a good week if you're a liberal. It's been a bad week if you're a conservative, and it got a little worse with the actions of Donald Trump if you're a conservative and having to eat that. But, I want to talk about all the stuff, the social ramifications of everything. And one of the first things I want to get into that I think also was a bad week for another person here in the city of Houston, that was Joel Osteen. He had some members of the Church of Wells.
Those guys are awesome.
They are. They made their first court appearance today, but they're charged with criminal trespass. They made kind of I guess they went into the Lakewood Church, caused a little bit of a scene, and got themselves arrested, 6 of them. Showed up in court today, County Court 2. They were shown singing and praying out in the hallway. Guys, thoughts on this? Criminal trespass in a church. Interesting to me. Let me get your thoughts.
If you disrupt the church proceedings, the other folks have a right to worship too.
Yeah.
And that's all they're doing. It's not about the Church of Wells folks, members' right to believe or whatever the hell it is they believe. It's about their ability and right to interfere with someone else's worship. So in the same way that if you tried to vandalize a church while the thing was going on, that interferes with my right to go to a synagogue or my right to go to a Catholic church or a Methodist service. So they're absolutely right to sit there and charge them because it's not about what they want to say or do. You can do that elsewhere. You don't have the right to interfere with someone else's house of worship.
Casey, do you think the fact that one of the things that churches often preach is that everyone is welcome? In this case, not everyone is welcome. What are your thoughts on that whole, the conundrum there that you lie in?
I suspect, not a regular churchgoer myself, but I suspect the whole idea that everyone's welcome to come here and worship with us. You're not welcome to come here and exercise your freedom of religion if it impedes my freedom of religion. And I understand that they had done this one other time before and perhaps had been given a no trespass warning or something.
Yeah, don't come back, we don't want you here kind of thing.
Right, so I don't know exactly why they're targeting Osteen, but it seems to me that clearly that's what they're doing.
Yeah. He's become a target for a lot of people. Damon, the guys today, they said they might consider representing themselves. What are your thoughts on that?
Well, they say if you have a fool for a client, right? A person represents himself as a fool for a client.
Exactly.
Lucky for them, a Class B misdemeanor trespassing is not a heavy offense, doesn't carry a lot of time, and it to me, is one of those situations where it either is or it isn't. And I agree with everybody here. You have a right to be there first, and then they lost that right when they overstepped their boundaries. But I mean, nothing's gonna happen to them. They'll probably get a fine. They're in court too, so nothing big. I don't recommend it. I don't recommend representing yourself at all. But if you're gonna do it, if you're gonna have the gumption and the silliness to do something you're not trained to do, I mean, a Class B trespass case, I would say, would be the one.
I actually don't think they even had the right to be there in the first place. With the first no trespass order, I think at that point you're prohibited from coming back for any reason.
I didn't know if that was for them or for another set of the members. I'm not straight on all the facts of it. I know some people were asked not to come, and so I don't know if it was those 6, or if if a first 6 came and then another part of the church came.
That part is unclear. I don't think we have all the story there. I mean, we'll certainly get more. The fact that it's Lakewood Church is obviously going to keep this in the news. It becomes sensational just by the fact that you've got Pastor Joel involved in the whole thing. So,
do we know why they're targeting Lakewood?
I don't think that's come out yet. They really didn't say today. I think they called him. The only thing I know is they called him a false prophet. Which, I mean, look, that's been an accusation of many people. That's not unique to the Church of Wells to call him a false prophet. But that doesn't necessarily give them the right to come and go in there and raise a stink. But I guess we'll just see how this pans out.
He's just a big target. That's what it is.
He is. He is.
Maybe it's
global
congregation
target.
envy.
Or money envy.
Well, with the congregation comes the money,
Pocketbook
right?
envy, right? Next item I want to move to, Casey, you had a little bit of involvement in this case, or a big involvement in this case. Professor David Dow over at the University of Houston. The Texas Supreme Court, let's kind of walk back through the proceedings of this for those that aren't familiar with it, and I'm sure a lot of our viewers aren't. David Dow is a professor at the University of Houston. He does a lot of work on death penalty cases with writs and habeas work that, frankly, a lot of lawyers aren't willing to do. It's for little money, if any money at all. And the Court of Criminal Appeals suspended him from practicing in front of them. I think are trying to show a picture of Professor Dow up on our screen. There he is.
There we go.
And
Picture.
Casey, you were involved in appealing this suspension to the Texas Supreme Court. And unfortunately this week, the Texas Supreme Court basically said, we don't have any jurisdiction. Explain to us a little bit about what happened, if you can, with those proceedings.
Sure. I actually got involved with the case. The first motion that I filed was the motion for rehearing, and I was working with Nicole DeBoard and Stanley Schneider. What had happened was the CCA accused David of violating a miscellaneous rule that is inconsistent at best. And the question was whether or not by one day had he filed late. And if you know anything about the CCA and writ work, that if you try and go back and amend your writ, it's considered a subsequent writ. And that,
Right.
Good luck getting over that procedural barrier. So David...
The judges are so understanding on the Criminal Court of Appeals, too. I mean, they really give you such leeway, don't they?
Such an egregious example of just procedure over substance. And this was, I won't get into the details of it, but it was a very complex capital case. I mean, and this guy's staring down lethal injection.
Right.
And so if we're going to give leeway or any kind of consideration in any case, this should be the kind of case. So David has issued, the CCA considered his late filed motion, denied relief, executed his client, and about 6 weeks later issued a show cause for he and his co-counsel to come up to Austin and show cause why he'd filed late. And we got an oral transcript of that hearing, and it was just, just a flogging session. They wouldn't let him finish his sentence. They weren't interested in the actual reason why he had filed late. And to me, in listening to it, it seemed like the fix was in before he'd even gotten there. Mm-hmm. And so when they recess, they tell him not to leave the courtroom, and when he comes back, they say, we're going to issue a sanction and suspend you. We're going to issue a sanction, hold you in contempt, and then suspend you from practicing before this court for a calendar year. The largest problem with that is that in holding him in contempt, suspension that's not a penalty for contempt. They can fine him or they can put him in jail, but you can't suspend him from practicing law. And their own rules, when they articulate the sanctions that they can issue, it includes referral to the Office of Chief Disciplinary Counsel, which is how you initiate disciplinary proceedings to get someone's license suspended. And so they violated the process for an officer of the court to be held in contempt. They issued a sanction that was just frankly illegal. I mean, the Texas Supreme Court has the exclusive authority to regulate the practice of law in Texas. Our motion for rehearing was denied. Justice Alcala wrote a beautiful dissent that actually followed the law. And then the Texas Supreme Court, the opinion that came out this week, and I can just say it was a punt.
Yeah, we don't want to deal with it.
Correct.
Pat, you do a lot of death penalty work.
I do.
And
Some of it with Casey.
right, and this is really a affront to the lawyers that practice
This
death
is
penalty work.
the moral of this is beware the fury of a patient woman, this is a personal feud between Chief Judge Keller and David Dow, and it has been that since the Richard case, where she closed the doors early, and the state bar, not the bar itself, but members across the state signed petitions for disciplinary action that resulted in a public hearing. against her. That was a difficult time for her. And I believe that this was at least partly the driving force behind this. Now, when Casey called it a punt, the most difficult thing about this is that the Supreme Court of Texas said that they do not have jurisdiction over the Court of Criminal Appeals, which essentially lets them run amok without on other issues like this. And that's why this is so important. And I think that she and Nicole and Stanley should be lauded, because this is about fundamentally how we are able to sit there and run our own bar. And if a court can do something that seems pretty clearly out of line and there's no one to stop it, then we've lost the ability to govern ourselves.
Right, and I mean, this sends a chilling effect, doesn't it, Damon? I mean, this rulings like this really, they send a chilling effect to lawyers in the sense of, man, do we really want to get involved with this stuff? I mean, it's not glamorous work as it is.
It's the glory.
You know?
It's the glory, the free kiddie meals. That's why you do this.
Right.
Absolutely.
Can I
Trips
speak
to
about
Austin.
that chilling effect for just a second?
Yeah, absolutely, because I want to know, because I feel like something like this does, it really sends, especially to young lawyers.
Yeah. Be
You know?
careful. Be careful who you question. Be
Yeah.
careful which authority you challenge.
Exactly.
Because there will be retribution.
Right.
And they're patient. Stanley has a personal relationship with David, and when he found out that David had gotten suspended, said, "Hey, let's help you." And immediately, myself, Stanley, Nicole hopped in, and we started working on this motion for rehearing. And we asked some criminal defense affiliates around the state to perhaps consider signing on as amicus counsel or through their strike force. And I've been practicing law for 10 years, and to some extent, I'm still a little naive. But I was surprised and frankly a little disappointed at the number of folks in a leadership position who their knee-jerk reaction was to say, well, maybe we don't want to get involved with this. And it had nothing to do with whether or not what the CCA had done was legal or whether or not David even deserved that type of punishment, but it was fear of the exact same retribution.
Right.
And I got to tell you, Stanley got an opinion from the CCA a week and a half ago that was just absolutely contrary to the law and the facts, even though the trial court had recommended relief. I left myself scratching my head, wondering, is that too retribution? And that's the kind of chilling effect I'm talking about.
Right. I mean, what's the solution to that, guys? I mean, we got to get strength in numbers, I feel like, but these people in power, they keep trying to throw this stuff out here and put this, make it more difficult for lawyers to even practice.
Jimmy, for the Chief Justice and CCA, it's a two-part solution. Those are elected positions.
Right.
And as we've always advocated, get out and vote. When you don't like something, get out and vote.
But you say that,
Make the change.
but how do we educate the public? Because what does the public really care about?
We're doing it now. And you speak to the public, and like I tell all my friends to go vote. I don't tell them who to vote for. They may ask me, like, this judge, that judge, and I give them my opinion, but I do my best to tell my circle, friends, family, anyone who can vote about things, and hope that they would go vote. I mean, as we have always seen, voter turnout is not very high, right? And so elections can be swung by a good number of pull from people to go out and say, hey, this is an issue. Another thing I think is important when it came to David Dow is recently there's been a lot of press about bad prosecutors, bad prosecutors. And I don't think the government likes bad prosecutors getting the press. I think they'd rather see bad defense attorneys and say, oh, well, this guy maybe wouldn't have gotten executed, but for his defense attorney not messing up. I would have said no, but that. And I think it's when you point the finger at us, at defense attorneys, it makes everybody feel easier. And we're not like that much anyways. And so I think this is an idea of just passing the buck from just bad prosecutors and say, look at the defense attorneys being bad as well. And B, to make the change you're talking about, I mean, just get out and vote. If we're silent, nothing will change.
I'm actually going to point fingers at defense attorneys, and I'm going to say that we have to stop being scared.
Yeah, I agree with that as well.
Our job is to stand between citizens and the government, right? And if we're not going to pursue legal remedies because we're afraid of retribution, then turn in your bar card.
Well, and here we are. We're on the eve of 4th of July weekend, and today our organization, the Harris County Criminal Lawyers Association, thanks to our own Rob Fickman, started a movement to have the Declaration of Independence read on the courthouse steps, and his goal was to get it read. He started a movement to get it read on every courthouse steps in every county in Texas. He's got it to about half so far.
More than that, actually, 134, I believe.
And it's gone beyond the borders. And we've got people, while they're on vacation, reading it at the courthouse where they're on vacation. Other people around the United States who have taken up the torch. We need more stuff like that, don't we, guys? We need more movements such as that, not to be scared to take on people. I mean, that was the whole point of why we declared our independence, is to take on people and stand up to those who would kick us down, right?
Yeah, there's this idea of the extreme absurdity. Like if you've ever done debate or any kind of logic, you have to take something to the extreme absurdity.
Yeah.
And I like to think that at some point the CCA is going to be just publicly humiliated and bring so much shame on the state of Texas. Like, let's just see how shameful they can really be. So keep marching the cases up there and see how egregious, how shameless they can continue to be. And I think that's just keep giving them the attention that they crave.
You know, Casey, I would agree with you. Prior to this week and the things that Ken Paxton and Governor Abbott have done as far as gay marriage, I know we're going to get there in a second, but as far as the decisions they've made about how not to follow that law, I would have agreed completely with you. That if we keep putting them in the press and showing just how idiotic and silly this stuff is, they would change. But after this week, I don't think they'll change. I mean, I think it just comes down, in my opinion, just voting. We can fight them all day long, but we vote.
Well, but
we get them out.
You know, we Harris County Criminal Lawyers Association, we have a Facebook page. We have a Facebook page for this show. The organization itself has its own Facebook page. We have a Twitter, which you can send us your questions and your comments at HCCLA_TV. And we'll take them live here on the air. But we have that. The organization has its own Twitter. We've seen things spread like wildfire. We've seen movement spread on social media. At what point do we as defense lawyers need to use that tool as a means to stand up? We've seen it cause revolutions in other parts of the world. How can we utilize that to stand up to some of this? I mean, the best way to describe it is a somewhat tyrannical type of actions.
Mr. Paxton's going to have his own problems in the next couple of weeks.
Yeah.
Well said.
You know, the nice thing about people who are extraordinarily ambitious and not particularly worried about how their ambitions run is that they tend to destroy themselves out of greed or desire for power. And Mr. Paxton is facing a grand jury indictment soon for securities fraud, an ironic thing for an AG.
Right.
And if you read his statement carefully, it was essentially, I'll be right behind you while you get sued or held in contempt by whatever federal judge decides that you're actually going to follow the Supreme Court and the law of the land. This is no different than the civil rights struggles. States' rights has always been a cover for bigotry. It has never been anything else. The only states' right that was fought for in the Civil War was the right to keep and sell other humans. The only states' right that we're talking about here is the right to somehow ignore the fact that everybody gets entitled to the benefits of marriage, or as I would like to say, everyone's entitled to suffer along with the rest of us.
Right.
So,
well, and I want to, you know, while we're kind of transitioning here, let's kind of get to the SCOTUS, Supreme Court of the United States acronym. And one of the things I want to get to before we talk about the gay marriage thing is another states' rights issue, and that's they upheld the use of the lethal injection drug.
Sure.
I find this to be a very big opinion. It didn't get that much play, but I do think it's a big deal, given the way it has been used recently and all the controversy with some of these injections gone wrong. You guys who do a lot of death penalty work, what are your thoughts initially on the opinion and what it means?
I read over the opinion before coming on tonight, and specifically, the opinion requires you to establish if you're challenging it in habeas or some other way, it requires you to not only establish that the drug creates a danger, but you have to find a less painful alternative for execution. So you get sort of an absurd comic image in you of a Monty Python skit where you have beheading, crucifixion, or lethal injection, and we don't really know what's in it. Could be anything, but it is a reaction, I think, to by the conservative wing of the court to what they consider to be a specious argument, which is that essentially, in their view, there is no pleasant way for someone to be executed. The humane way is to do it reasonably quickly and reasonably painlessly. And thus they've thrown up a hurdle. If you read the opinion, there are some ways to go back in on this, and it actually may help us challenge Texas's secrecy law about the corporations that manufacture this stuff, because we have to be able, under this, to bring a challenge, we have to be able to actually know what the drug is.
Right.
So it may potentially provide us a way in along that angle to challenge the ridiculous corporate secrecy law that Texas passed this past session. That said, this will continue, and hopefully we'll get some more shots at it. But for now, these cocktails are going to continue.
I feel like, and again, it's that extreme absurdity. Why don't we just, you're going to sentence them to death. Why don't you let them pick? If you want to die by firing squad,
Utah allows that.
guillotine, whatever. I mean, the point is that your government is killing citizens, and I have some philosophical, I'm not opposed to the death penalty completely. I'm opposed to my government imposing the death penalty. And so,
Please clarify what that means. I'm just curious from my own curiosity. Like, are you okay with citizens killing citizens in self-defense, or?
No, I'm saying I understand the idea of retribution and rage. That if someone were close to me that were murdered, I understand on a personal level that desire to exact your own type of revenge and retribution, and take and issue the sentence yourself, right? But when you turn something like that over to the government, right? And there's no wiggle room. You can't get a do-over, and it's so wrought with opportunity to screw up, right? And they've created these procedural boundaries that keep you from, that prevent lawyers, David Dow, from stopping innocent people from being murdered by the government. It's just not something I entrust to them.
So, Casey, I want to take a step back, and you too, Pat, rewind. We've talked a lot about procedural ways and death penalty, how it works procedurally. What is the death penalty appeals procedure? So now I've gone to trial, I've been found guilty. We haven't even talked about how you get certified for death penalty case, but now that I'm found guilty of death penalty, I'm sentenced to death. Procedurally, what are my appeal steps, and what are we talking about when you talk about an appealing a death penalty case?
You might need a flow chart. Get it, Pat.
You do. In Texas, every case from the trial, death penalty imposition goes directly to the Court of Criminal Appeals, because under our Constitution, they have final jurisdiction in all death penalty matters.
Right.
At the same time that the appellate lawyer is appointed, a state habeas attorney is appointed. That habeas writ is supposed to be filed, not when the appeal is completed, but sometime after the state's brief on the appeal side is filed, the appellee's brief.
And when he's saying appeal, it means direct appeal.
Okay, all right.
So those two things are pending, one in the district court for factual findings and review, and one at the CCA.
And the one in the district court is to try to get a new trial or get the verdict overturned somehow?
All of them to try to get new trials, but a direct appeal, as some of the listeners may not know, is limited to the matters in what we call the record. It's limited to the motions, pleadings, and testimony at trial, and the rulings on those things. Habeas is about the facts. It's about bringing in other facts that were not found, witnesses that were not available, witnesses that recanted, finding out, for instance, that the state is often running a backdoor deal on witnesses that come forward and our jailhouse snitches, for instance. That's one of the biggest sources of wrongful convictions being overturned, is getting them to recant. So you bring those facts in on the habeas.
Okay.
If the CCA denies the appeal on the direct appeal, you have a shot to take that to the Supreme Court of the United States. They sometimes take those, but not often. Your habeas then goes forward in the state court. You try to bring in new facts, get an evidentiary hearing. If it is done in the state court and the judge recommends one way or the other, it goes up to the CCA. Again, it actually does come together in the state system because there's one court that handles death matters.
Right.
That habeas will come in, and they will either grant or deny relief. That's what it's called. If they deny relief, which is the typical result, then you have under the statute 15 days to seek appointment of counsel in a federal district court. You can also take that denial to the Supreme Court, but that's not a typical route because it doesn't stall any time. In the federal system, you're under a statute that was done after the Oklahoma City bombing called the Anti-Terrorism and Effective Death Penalty Act, the DEPA. It was passed in 1995, and since then, you have 1 year from the time of direct review ending to get either a state habeas to toll the deal or a federal habeas in the door. Otherwise, you're time barred.
And so the DEPA part comes in after you've won or got relief granted or denied in the state habeas.
Yes, although typically denied, because if you've got relief, then you're back
you
to trial.
move on. Once denied in state habeas by CCA, the Court of Criminal Appeals, then you have a road to the federal courts as well.
Right.
If you elect that route.
Right. And the district court, under a DEPA, has to give great deference to the state court's findings and determinations. It becomes, as Casey said, it has become an increasingly narrow, inverted funnel if you go up, where you hope to avoid a death sentence at trial by any means necessary. Then you have an appeal and a habeas that increasingly become limited because as the feds review it, you have narrower and narrower ability for the feds to sit there and overturn a state court's findings. Right. And the Supreme Court, has actually taken a significant number of death penalty cases over the years, many of them from Texas, because
we put more people on death row than anybody. So
that plus
probably most in Harris County.
Right.
Plus, we're blessed with the ability to abuse the system in a way that no one else does. John Paul Penry was the beginning of trying to get mercy questions, what we call mitigation, into the system. From there on, they've had
Millerell,
decisions.
how many times did that bounce up and back?
Yep, Millerell, and that was, again, on a system in Dallas that was actually training people. I know this will shock people, but the Harris County system was similar to the Dallas and still is. They're trained to strike minorities. Whatever one may say about Judge Lykos and how she ran things within the division, when she fired people for striking minorities, suddenly, lo and behold, like snow leopards, we had black people on juries.
And when you say, so there we go, you say striking minorities, we're talking about when the county calls people down for jury service, the state, voir dire, picks people, and they were striking people based on color.
They still do, they're just better at hiding it.
Which is illegal.
It is absolutely illegal. It interferes completely with, and it's not even about the defendant's right to a fair cross-section. This is about denying people a basic tenet of citizenship, which is the right to sit as jurors in a court of law and determine issues.
I had a Batson challenge granted last week by a black prosecutor.
For striking all black jurors?
For she struck a black man who literally hadn't so much as hiccup during the voir dire proceedings. And when I made the Batson challenge, she was caught sort of flat-footed, like shocked that I would do this. And I did it, and she couldn't articulate a race-neutral reason.
And a Batson challenge, just quickly, is what?
So when we make our strikes and the judge puts the jury in the box, he asks both parties, do you have a reason to object? Does either party object? Yes, Your Honor, I object. I'm making a Batson challenge to juror number 63. State, race-neutral reason. And if the state cannot articulate a race-neutral reason for striking that person, it's granted. And it was a beautiful moment because he invited Miss Asian Lady to stand up from the jury box, take her seat in the veneer, and Mr. Black juror to go sit in the box. And I'd busted the first panel, and because of like a race riot that I'd almost started, this idea of racial profiling. And to have that happen with this jury on this case was just phenomenal.
I want to touch on the race thing, but in my next question. But first, I want to do a little reset because it is 8:30, and I want to remind our viewers we're going to open up our phone lines 713-807-1794. If you'd like to call in with questions for us, please do. We also are taking your questions on Twitter at HCCLA_TV. Any questions, any comments you have, please send them our way. Guys, you talked about the race stuff, and we've had a lot going on the last couple weeks with South Carolina. The governor there, a white governor, has come out and called for the death penalty against the shooter, that they should seek the death penalty in that case. And I want to get from you guys, not whether or not they necessarily should and what South Carolina would do. I want to take it to Texas, because that's where we practice, that's where our viewers are. What would happen with that case here? Because we've often argued and often heard that minorities are the ones who are often targeted for the death penalty. It's a mostly minority-driven penalty that's sought. Do you think that a young white shooter who murders 9 black people in a church, would they be facing the death penalty here in Harris County?
In Harris County, that might be different. But the other part of it is that throughout this state, race has played a part in who winds up on death row. Anyone who looks at the stats, they are 19% of the population in Harris County and over half of the people that are indicted for capital murder in this county. It is ridiculous to sit there and deny the impact of racism in the death penalty.
Right.
But that said, the irony of this in South Carolina is that for the death penalty is a political instrument. For it to be politically viable in South Carolina, it has to be sought against this young man. Not because he may not be mentally challenged or insane, but because that governor cannot sustain a death penalty in that state if he does not pursue it when it's done against blacks by a white person. That's the irony and the strange bedfellows that the death penalty make.
Yeah.
In terms of here, look, and you actually said this case when we were talking one time, is it's everybody who gets selected for the death penalty, crazy, intellectually disabled, or black. Is that just the rule? And I said, no, but it helps.
Kind of a de facto prerequisite almost.
This is a penalty in search of a problem at this point. And I'm not even going to start with the fact that it's hard to deter other people that suffer from mental retardation.
Exactly.
Now, granted, they've eliminated that category, but it has been narrowed. It has been limited. But we now appear to be back to the good old days under that I grew up with in the 90s. Of if you can make a death case, you make the death case, period. We have 16 or 17 people now facing death cases in Harris County. We haven't had that many in 7 or 8 years. And that's the randomness of this. If you have a different prosecutor, you have a different criteria for killing. Now that discretion may be lawful and it may be electable. But I got to tell you that if your chances of getting a death penalty depend on whether it's prosecutor X or prosecutor Y, then that's ridiculous.
You're screwed.
We have one of our viewers on Twitter tweets at us and asks a question for both of y'all. Have you ever witnessed a Texas death penalty execution? And if so, what was that experience like?
No, I have not.
No. We actually thought, my colleague Mandy Miller and I were actually prepared for that this past January and didn't have to. So that was actually very fortunate.
Yeah.
So to piggyback on Jimmy's question, if that shooting were to happen here in Harris County and the DA decided to pursue a death penalty charge and course of action against the shooter, procedurally, what steps would have to be taken to get from crime, arrest, to now death penalty trial and perhaps conviction?
In Harris County, it mostly depends upon the line chief. The chief prosecutor in the case makes a recommendation that goes up the chain to the division chief. They used to write a death memo on why this case should go death as opposed to not. And allow me to point out that even in this county, the political nature of the death penalty is extraordinarily clear, because I have had clients who have killed 2 drug dealers and gotten terms of years. Kill a cop, and you're going to face a death penalty automatically.
Right.
That's a political statement. That is
It
not.
absolutely is.
That has nothing to do with the facts. It has nothing to do with the person that they're charged and their qualifications, or what we, in a weird twist on fate, call deathworthiness. Yeah, it's an ironic phrase. It is a political statement about what the prosecutor's priorities are.
Right.
Well, and I have to comment on the system, right? If we accept that most of the folks that are charged with, accused of capital murder are black and brown, poor, and very often intellectually challenged,
Right.
damaged,
Yeah.
emotional problems. We have a system in Texas, right? You have to take some tests, you got to get on a list to be appointed to represent these folks. There is a dearth of folks that are now qualified to represent capital clients at trial. And of the ones that are qualified and not receiving appointments, I'll suggest to you it's because they win.
Yeah.
So they just don't get appointed.
Well, but that's been a historical problem, though, is that if you win your cases, or if you even, it goes back to what we were talking about before. If you
fight
push
your
back,
cases.
if you push back,
Yeah.
you don't get cases. You don't get appointments unless you line them up in the plea mill.
So this same system that says this is how you get on my list,
Right.
if you ever admit that you've been ineffective on a writ, which largely on capital writs, that's all we've got.
Yeah.
All we have is ineffective assistance of counsel. If you admit that, you're off the list. And so the system has created this conflict of interest between these folks, these underprivileged folks that are reliant on the system. They've created a conflict between them and the people that are supposed to be fighting for them. And I will tell you, I do writ work, and there is a stark difference between retained counsel admitting when they've screwed up versus court-appointed counsel, because they will take that to their death.
In what way?
And-
Describe the
and-
difference.
In speaking with a court-appointed counsel about, can you explain to me what your trial strategy was? If they take my phone call, if they talk to me, right? So let's get past that threshold first. You'd be surprised the crap. They're defensive, they yell, they hang up, they don't want to give me the file, and it's because I'm threatening their bread and butter.
Goes back to the retribution thing. They're fearful of not getting, that appointment from the judge, or getting how they make their living.
I met with a retained lawyer earlier this week that's been practicing a few years longer than me, and it was on a writ, not a capital case, but just a writ. And I asked him about this issue, right? He maybe misquoted the law, and I was surprised. Like, I had not held this fellow in very high esteem, and he was like, "No, that sounds about right. I didn't understand that part of the law." No, you're right. I screwed that one up, and it caught me back because I've been working on capital cases for so long. How willing he was to admit that he'd screwed up. And it was a complicated piece of law, but just that there is, and Pat, do you see that difference?
I see the fear difference. I think, and there's certainly
Well said, fear difference.
And the only actual penalty is in the capital realm. In other words, in no other, a judge may decide to take you off an appointment if they decide you were ineffective in a case. But there is no requirement, unlike in the capital side. In the capital side, it is for the appointment list by law and rule. If you are found to be ineffective, you are removed from the list and then allowed to reapply.
Is this list specific to county specific or Texas? Like this?
It's regional.
Regional, yeah.
Yeah, we're in the 2nd Judicial Region, so if you're on the appellate and trial list, then if you're found to be ineffective, and found means a legal decision by the CCA or by the district courts in federal system that's upheld, because they've gone through that too, but that means that you're booted from like a first-year position and you're allowed to reapply as a second.
Okay, just for that region.
Yeah.
So
Well, if
theoretically-
you take them in the other regions, that's the same.
Okay,
So it's a statewide ban, essentially.
right.
Yeah.
Yeah.
It's just we can't solve all these problems. There's death penalty creates.
We can. We have 10 minutes. Right?
Yeah, well, we can. Now I want to switch to the big topic that happened this week, and that is
Which is not even criminal in nature.
it's not even well, but there it can go in a lot of different directions. So, of course, the Supreme Court legalized same-sex marriage last Friday, and as I said at the top of the show, great week to be a liberal, bad week to be a conservative. But more so than anything, I think it's a good week if you're just about fundamental fairness and expanding rights and giving people the right to do what they want to do. I mean, and then you have our idiot Attorney General and our local county clerk saying they're not going to issue marriage licenses.
Right.
They have to get all these opinion letters. And thankfully, Vince Ryan stepped in and said, Stan Sanders, you better do what you're supposed to do and do your job.
Do you want to handle the fact that he's demeaning idiots by comparing them to the Attorney General?
Yeah. I do want to talk about this idea, though, of this freedom of religion, right? Ken
Right.
Paxton letter said basically that you have an obligation to protect your employees' freedom of religion. It has long been the law that government employees don't have an unabridged First Amendment right to speech, right? And so if you're speaking as a citizen about some public interest issue, then certainly your freedom of speech is protected. But if you start talking about your duties as a government employee, and that speech affects efficiency or effectiveness of the government function, then you can be fired. And so along the same lines, yes, you have a constitutional right to religious freedom. Not if but it can't be used to deprive other citizens of their rights. And if it affects the effectiveness and efficiency of that government function, then find another job.
Yeah.
Yeah.
I
Seems reasonable.
And it's
agreement.
even more carried to the point, it's now the law. No matter how you feel about gay marriage, no matter how you feel about it, it doesn't matter anymore. That question was solved. Like, you can be for it or against it, and now it is what it is. So for you to be an elected official, for you to have the power and authority to issue a marriage license, you've been told by the highest court in this land, and depending on who you are, I believe the Supreme Court is the most powerful government entity. Some people say president, some say Congress. It's good arguments either way. But in my opinion, you've been told by the people who interpret and enforce the Constitution, for which all laws are from, that you have to allow a gay marriage now. You have to let homosexual marriage go through.
And the irony,
why fight it?
Right, and the irony of this is for years they've been prosecuting assault family violences involving two
Same-sex
couples.
Yeah.
You know, so they
Because
certainly,
clearly we've got it right.
yeah. I mean, but,
You know,
but
if
they
there was
clearly aren't-
ever a shining example with a 50% divorce rate in Texas, I think it's clear that we've got this down.
Yeah, I mean they have the right to be charged with a crime if they're in a same-sex relationship, but they didn't have the right to be married until last Friday.
Well, and so that's kind of true. I've actually seen in one court in Harris County, I'm not going to say which judge it was, but it was a same-sex relationship, but they weren't living together. And so that judge ruled, hey, since they're not cohabitating, then the definition of domestic includes people living together. So just friends living together can be a domestic fight. He said because they're not living together, you can't charge this as domestic, it's just regular assault and go about your business. And that's what this one particular judge said. But you're correct. In the other counties and other courts, I mean, it is what it is. A spade's a spade. And I like I said, no matter how you feel about it, just go ahead and issue the doggone license, because it is embarrassing. And I'm a proud Texan, and I'm a stupidly proud Texan. And it is embarrassing to have this decision come down, and then the entire nation look upon us and they're like, come on, just get the doggone license and move on, you know?
Extreme absurdity, bring it on. Like, just keep
Yeah.
doing it. So I looked at this before I came on the show. The Stan Standards office also processes applications to serve beer. And so if it is your religious belief that consuming alcohol is a no-no, then what, are you going to refuse to issue beer licenses now?
No, there's too much money in that. There's too much money in that. You can't deny liquor licenses.
But it's a ministerial function. You know, you said something earlier about the power and authority. No. It is a ministerial function, which means when someone says, hey, I need to do this, you just give it to them. You don't get to inquire or make questions. It is a ministerial function.
I'm very troubled by the fact that we have elected both an attorney general and a governor who are both lawyers who don't seem to grasp this fact. I mean, how does this?
You can respect.
How does this happen?
Well, you can respect someone's religious belief that sits there and differs from your own, but I think for most people, to put this in perspective, substitute gay with Jew, black, Asian,
Right.
Baptist.
Absolutely.
And suddenly, what they're proposing is a return to a time when there were state-sponsored religions. And that is exactly what I know my ancestors wanted to get away from.
Exactly.
So that, what Casey says about this is very elegant and simple and profound. It is that you have a job to do, regardless of your personal beliefs. We've entrusted you to work for all of us, not just those that you happen to agree with. And that's an unfortunate political ploy, but as I said, Mr. Paxton will have his own issues to deal with in the near future. I don't believe that this is going to go anywhere because, even governors can be contempted by a federal district judge.
Sure, but I mean, Paxton is under investigation for securities fraud. He's now put out all these ridiculous memos. At what point can we say enough is enough? This guy he's in a position of trust. He's the Attorney General. He's charged with issuing opinions and helping interpret law for the state. And I gotta be honest, he's failing miserably at this.
I don't suspect he'll have the job much longer.
I don't suspect so either, but still, there's gotta be an interim solution here that we can.
But the voters picked him.
I understand
right?
that.
So back to vote, back to vote, back to vote. But even if, and I don't know this, so maybe you guys can educate me. Assuming Paxton gets booted tomorrow, who picks his successor? It's going to be Abbott, correct?
I think it's an appointment. Is it not a governor's appointment?
They have to call a special election.
Got you.
But just because Paxton, if he let's assume.
The deputy attorney general would be acting,
Right.
Until the first assistant would be acting until a special election's held.
But assuming he is indicted, Governor Perry was indicted. He didn't have to step down from office.
What was it Governor Edwards said in Louisiana? Indicted, never convicted.
That's right. Well, he was convicted
Eventually.
eventually.
Third try.
You said something earlier, and again, in preparation for being on the show, I went back and I read.
I'm glad you prepared.
Yeah, I
that
appreciate
that.
that.
Warms my heart.
Prepared, yeah.
It makes me feel good.
I went back and I read Loving versus Virginia.
Yeah.
Which was the
Nice
Supreme
old
Court
case.
case that said that that you can't discriminate against interracial marriage, and it was uncanny the number of arguments that were being advanced by the state of Virginia that we're hearing today. Like, I literally went to the Human Rights Campaign website and volunteered after reading Loving. Like, I'm a lawyer in Harris County, and this is the civil rights movement. This is what was the civil rights movement from the 60s. It's happening today.
And I'm
right
glad
now.
you mentioned Loving because one of the dissenters is, of course, Justice Clarence Thomas. And I mean, come on.
Who's married to a white
Who's
woman.
married to a white woman.
Right.
And for the love of God, how can it just makes my head want to explode that somebody like that can side
Cannot
on
understand, right?
discrimination
Cannot understand.
against discriminating people against people.
With Justice Thomas, I think two things. I think one, he doesn't get it, but two, I think he's really lazy. And so I think he doesn't want to write an actual opinion, so if he dissents, he can choose to write a dissenting opinion or
Right.
not. But if he actually concurs, he might have to write the opinion.
He
didn't want to do
instructs
that.
all of his clerks to write those opinions, and he's the same justice that came down against affirmative action, like one of the most vocal justices against that. It's like he doesn't know that he's black, or he got some special privilege to get. It doesn't apply to me. It doesn't apply to me, and I think it's irresponsible. I think he's irresponsible, and.
And to be fair, I don't think him being black means he should go out and be for same-sex marriage. I don't think that at all. But I do understand that I don't get how he can be so against it in light of how Loving v. Virginia has influenced him.
Well, I mean, the term hypocrite comes to mind, pretty right
That's
off
a
the
good
top
one.
of my head.
That's a good one.
Right. It's hard to not bestow a benefit to someone else that you have received yourself. Right.
Yeah.
Or that to me is a difficult task, and I don't understand how he does that. If you asked any lawyer, this decision was a long time coming and it was going to happen. Like, it was just in the water. It was only a matter of time. I don't see the resistance towards it. No matter how you feel about, like, same-sex marriage, no matter how you feel about it, it's done. I've said it before. Move on. And I go back to it again. I'm really upset at Paxton because he's making us look bad. I mean, we look stupid with him keep making these silly arguments. And one thing I don't like, as a religious person, and I am religious, and deeply religious, I don't like anybody using my religion or any religion to force upon my beliefs on someone else. Because you make us look bad now. You make every Christian look bad when you're like, oh, it's my religious belief to be a bigot. Now we all look like bigots, and that's not who we are.
Can I ask you a question? I know that in the Bible there's a prohibition about man lying with man and spilling of seed, but does it say anywhere in the Bible that men can't get married, or is it just about the sex thing?
It defines marriage, so good point. So Leviticus has all the man lying with man and woman and incestuals, that kind of stuff. But then it goes on to talk about marriage, and it talks about marriage between a man and a woman.
Okay.
So it doesn't specifically say a man can't marry a man. It just says a marriage is between a man and a woman. So it delineates that separation or that definition of what marriage is. And all the examples, all the qualities of marriage in the Bible are man and female.
It always struck me about this man laying with man and spilling of seed. That technically doesn't apply to women because we don't have seed to spill.
Good point. Good point. I want to kind of take this decision and bring it into a criminal law realm, which is what this show is about. I was reading the bigamy statute here in Texas.
Right, it's gonna be gone.
And I wonder how that holds up. Hopefully we might try to get our own Mark Bennett back on the program to talk about this. But
I'm not familiar with the bigamy statute.
Well,
it prohibits multiple marriages. However, it would certainly be subject to a First Amendment religious-based challenge, which brings back in Mr. Paxton and Leviticus. Since Leviticus talks about concubines and multiple wives, you, as a man in Leviticus, you were not forbidden from having more than one wife.
Oh, well.
Yeah. Oh no, you're not in it.
I'm screwed. I can't have multiple husbands.
Yeah.
Can I have multiple wives though?
I think so.
I mean, I guess if you want to interpret, if you're not spilling seed,
Pretty open.
why not?
I got
Right?
no
you might be too much for multiple wives to handle.
I got no speed to.
I don't know why a man would want multiple wives. Don't get me wrong,
But this is the part you have a deeply held religious belief among the Church of Latter-day Saints.
Yep.
The Islamic faith permits up to 4 wives. The truth is that statute has been vulnerable to a religious-based challenge for some time. Whether one would sit there and say that the state's interest in protecting the sanctity of marriage and the protections for that apply to not, strictly scrutinizing a bigamy statute, other than for religious grounds, is a different matter. But again, this would have to mean that if you had actual polygamy, that means that women would be able to have multiple husbands.
Well, yeah.
So they would actually be able to get a handy guy, a good-looking guy, and one who actually makes money. So finally.
So as the only one on the show, Casey, let me ask you, would you ever see a situation where you'd want multiple husbands?
No.
Yeah, I wouldn't want multiple wives.
Do you see a situation where you want a husband?
No.
Right.
Or a wife. Like I have 2 dogs and we live in joy. Those are my life partners. I like it that way.
Yeah, I do agree that the polygamy and bigamy statutes are wide open, and that's gonna be interesting because there's no reason, other than the fact that you don't like it, why it shouldn't be. I mean, I guess there could be some policy concerns as far as courtroom time and as far as how the courts are gonna deal with a separation of a polygamous couple, but I mean that shouldn't be a reason.
We have that now. If you have more than one, if you have multiple divorces, you effectively have all of the legal impediments and problems with a marriage and child support if you pay spousal and child support without the benefit of cohabitation or affection.
Well, no, but that's different than if I have multiple wives, because then if I like right now, I married my wife when I was 23. If now polygamy is allowed, I'm 33 and I married Casey. All right, so now I've got 2 wives. I had my first wife for 10 years, Casey for a day. And I divorce both you guys tomorrow, or let's say 5 years from now, when I've made real money. Are Casey and my wife Jonay equal under the law as far as what they should get?
That's a good point.
I mean,
Well,
Jonay's been 15, you're 5. Should y'all both get the same? Or if not, it's almost like the law will put a value on the length of time you've been married to somebody as opposed to their contribution to your marriage.
But we do
and
that
Damon,
now.
that's the big deal. Is I see this multiple marriage or these multiple spouse thing just a ripple effect in all the other statutes. I think about probate court and this idea of per stirpes inheritance. I mean, it screws everything up because the entire statutory scheme is based on 2 partners, just 2.
But should that be enough to stop it? I mean, should the law, should that, in your opinion, be enough to stop if you really believe that they're entitled legally to polygamy and bigamy, should the fact that the law hasn't caught up to it yet be enough to stop it?
This is not my legal opinion. This is my personal opinion. All of the communities that support polygamy, plural marriages, typically are patriarchal societies that are not fair to women, and they're very often abused and subservient, and they don't have equal rights. And so, no, I am not a proponent of multiple marriages, period.
I think you're going to have a lot of people who feel that way, that they're not a proponent of it for the exact same reasons that you said, is oftentimes there's abuse. But, you know.
Let me restate that. I'm comfortable denying them the right to have multiple marriages. Like, I wouldn't want that to proliferate in my community.
Well, that's a different issue. I mean, that's the thing. I mean, and that becomes, I think, the crux of what we're talking about. We all sit here and talk about Kim Paxton's memo and Governor Abbott's comments and everything, but I think they feel the same way that you feel, only about same-sex marriage.
But I'm not discriminating against these polymorphous folks based on any protected, immutable characteristic. Not because they're a woman, not because they're a man, black, Asian, Jew, any of that. I'm simply saying that I know what comes along with those arrangements, and I'm comfortable denying them the right to do that in my community. I would vote to do that.
So, but then aren't you then, Casey, placing a stereotype on those types of arrangements? Because I personally don't know any polygamists, bigamists, and if I do, they kept a really good secret. But assuming for the moment, we're just kind of saying that these women are all victimized. I mean, we don't know. Maybe they're not victimized. So aren't you kind of, in essence, putting a stereotype to them and then judging them based off their stereotype?
Well, you know, there's some truth in all stereotypes, but I think about the Warren Jeffs in that community, and then I think about the Muslim communities where they have multiple wives, and I can look at objective evidence from both of those communities and say there's nothing egalitarian about it. And so I don't know that that's a stereotype necessarily. Maybe my limited information, but I don't know that that's a stereotype. Now, I did see Big Love on HBO, and they seemed like a cool group of people. And so if Bill Paxton wants to move into my neighborhood.
Amazing what Hollywood can do with polygamy.
Talk.
Make it a feel-good story.
Make it fun and rich. I would want that still.
I mean, yeah.
No, but I think, Casey, your argument to me, it's kind of the same argument we had with Cat Stevens on the show about human trafficking and prostitution, and her belief that all female prostitutes, and just female, not men, were in some ways victims as children, and had they not been abused or whatever, they wouldn't be prostitutes. And I think, to me, what you're making that to me is the same argument, that based on the evidence you see, it's all bad and shouldn't be allowed. But
I'm actually being a sexist, is what I'm doing.
it's okay.
Your admission is on the record.
It is, in
And
fact.
with that, we got to wrap up our show here. And so I want to thank Pat McCann, Casey Gautreaux for coming on, Damon Parrish.
Pleasure.
Thank you for having us.
As always. Oh, we're going to have you back, don't worry.
Absolutely.
And to all of our viewers out there, we thank you for joining us. Tune in next week. We'll be back for another edition of Reasonable Doubt. You can follow us on Facebook and like us on Twitter. Send us your comments, your questions. And if you have any topics you want us to cover, send them our way. Thanks and good night.
Peace out, y'all. What?